Peter, please. Mark, could you just get the focus a bit better? Is it possible? Hello? Can you all hear me? Yeah? Can you hear me?
Yeah.
Yeah, great. No, I can't. So, the bad news is that I got a parking ticket. So, can I have a bit of sympathy? I've had hundreds of them. I never paid them. I used to put. I can't hear.
Keep it next to your chin. Keep it on your chin. No, on your chin there.
Yeah, there. Is that okay?
Better.
Yeah? A bit higher. Yeah?
Yeah.
Okay. I used to put no contract return to sender on all the envelopes, but I stopped doing that. I thought it was a waste of time, but all of a sudden I had a bailiff notice from Bristow and Souter from a ticket I got in Shrewsbury last August. So I thought it's about time to have some fun with them. So I started engaging with the council in Shrewsbury, and they started telling me all sorts of stuff. So I started to look into the forensics of how they claim that they can issue a warrant. So I started digging, and I started talking to the Ministry of Justice about it. And the upshot was that I got an email from the Ministry of Justice, which they reckon that this explains what it is that they do and why it is that the councils are allowed to issue warrants. And I was arguing that in the 1993 regulations, it actually says that it has to be a warrant of theory facias, which in modern language is a warrant of execution. But the Traffic Enforcement Centre and the councils keep arguing that they're allowed to print their own warrants. But I don't actually think they're allowed to. They've set up a system whereby it looks as though it's legal for them to do so, but in actual fact, the legislation says something different. And so what they've told me is that the 1993 rules and some of the provisions of the 1991 Road Traffic Act have been repealed. And I think what they're trying to tell me is that the requirement that they have a court-issued warrant has been repealed. But I somehow don't think that's actually true. Because what she's written to me is that the Traffic Management Act of 2004 has repealed some provisions of the Road Traffic Act of 1991. And so I decided to look into that a little bit more. And also the civil procedure rules, this was my main argument with them. The civil procedure rules, part 75, which is the part that governs council parking ticket enforcement, it says that a warrant of control, which is the modern term for a warrant of execution, and the warrant of theory facias, it means a warrant of control issued by a local authority under Article 5 of the 1993 order. But then later they're telling me that the 1993 order has been repealed by the 2004 Act. I know it's a brain twister, but this is the way that they actually get us to believe that they can do things which they really can't do. So I began to accept that the 1991 Road Traffic Act had been repealed, and here it is here. I know this is all a real drag, but knowledge is power. So this is under Schedule 12 of the 2004 Act. Road Traffic Act 1991, Section 76 to 79 have been repealed. Well, Section 78 is the section that says they have to issue a warrant. So on the face of it, it looks as though they've repealed the need for them to go to court to get a warrant. But if you then look in the Act that repealed that, which is the Traffic Management Act of 2004, in section 82, it says, the Lord Chancellor may by order make provision for warrants of execution in respect of traffic contravention debts or such class or classes of contravention debts as may be specified in the order to be executed by certificated bailiffs. So he's actually saying there in section 82.3a that there is provision for warrants of execution. Well, that, if I'm understanding it correctly, that means that this Act has repealed the requirement in the Road Traffic Act of 1991 that they have to issue a warrant, and they've repeated it in slightly different words in the Act that they claim is in force now. So my argument with them is that the law, the primary legislation, actually says that they have to issue a warrant of execution. And as I understand it, a warrant is a document that's issued by a court, not something that they print themselves. And sitting inside that distinction, I think they're actually playing fast and loose with proper law in statute. It's nothing to do with common law, it's just statute law. I believe that they are required to go to court to get a warrant. But they keep on arguing, and I've had loads of phone calls with these people, they keep on arguing that the councils are allowed to print their own warrants. I don't know if there's anybody here that actually knows anything more about this stuff than I do, and this is all fairly new to me, but it seems to me that... Yeah, please. Please, yeah.
That's a very important point that Peter's just made. Peter as well here, so we're almost like twins. What most people fail to realise is that when people pull you up on statutory legislation, that's the policeman at the side of the road, or the county council, or a warrant or the threat that they're going to put you into jail for non-payment of, say, council tax. Most of the legislation, around about 98% of all the statutory legislation that lays across your back, is not what's called primary legislation, which Peter mentioned, is what's called secondary legislation or delegated legislation. Delegated legislation is what's called a statutory instrument that the minister for each relevant department has the authority to pass on behalf of the government on the advice of civil servants in Whitehall. So, for example, acts like the Serious Organised Crime and Police Act, amendments to the Road Traffic Act, amendments to these pieces of legislation that I've spoken about, are all pushed through on something called a Henry VIII clause. And a Henry VIII clause was something that was a constitutional nightmare and has been consistently argued right the way through 1688 Bill of Rights by, shall we say, constitutional philosophers or people who wanted to protect your rights, because what it does is it gives the authority, so-called, for Parliament to say that it passed a legislation when in fact it didn't. A classic example is the production of your documents, say your driving license and your insurance, immediately at the side of the road, otherwise you'd have your vehicle seized. Now, anybody looking at the provisions of what's called the 1988 Road Traffic Act would see in whatever section, I think it's section 143, if you don't produce the documents immediately, the police officer has the right to seize the vehicle there and then, full stop. But as most of us might know, who are over, say, the age of 40, 45, it used to be that you had 7 days to produce the documents at the side of the road. So, you have a primary legislation, the Road Traffic Act, which has had antecedent legislation welded or grafted back onto it, and therefore what you do is you have the right to challenge the police officer or the court at the side of the road that it wasn't a democratically, should we say, statute law that has been imposed upon you, but it's a statutory instrument passed by the will of the minister on advice of some type of civil servant, and therefore you could argue it is not an act that has been passed by Parliament. The difference is an act has to go through a first reading, a second reading, a committee stage, goes to a final reading, then it goes up to the House of Lords, then it gets passed. A statutory instrument lays on the desk in the House of Commons for 40 days, and if it's not objected to, it becomes law. Thank you.
Fantastic. Well, thank you very much. I really appreciate that, because it really puts into perspective what it is that I'm trying to dig out. There's a lot of stuff in there that I didn't actually realise. That's fantastic. But one of the things that I'm trying. One of the things that I wanted to bring everybody's attention to is where all of this stuff is leading us, because I've got a screenshot here from the Citizens Advice Bureau, because what the people in the Ministry of Justice are telling me is that there are some circumstances where the creditor themselves are authorised to issue warrants. Presumably they're talking about councils, because this is what they do. They issue warrants for council tax and they issue warrants for parking tickets. But in many instances they don't even bother printing them anyway. They just tell the bailiffs to come round. So they never ever show you any documents. And I believe one of the reasons why they won't show documents is that they know they're fraudulent in the first place. Because deep down inside the system, they've been suckered in. The people that are actually doing the jobs have been suckered into thinking that they're acting legally, whereas the people that are instructing them know perfectly well that the whole thing is completely illegal. Because this legislation says that it has to be a court-issued warrant. They have to make a request to the court and get the court to agree that there's a warrant. And incidentally, you should be there to argue your case as well with the magistrates or whoever it is that's being asked to issue the warrant. But this is where it's leading. The Citizens Advice Bureau actually is saying on this screenshot, you can't read it, so I've actually typed out the text. How is a bailiff authorised? And what that actually says. This is Citizens Advice Bureau. They're actually telling the public that some creditors must get authority from the court, while others can issue it directly to the bailiff or enforcement officer themselves. But I find it absolutely amazing that things have become so degraded. The actual proper due process of law, even if you consider that statute law applies to us anyway, which most of us don't, but they've got so far from due process that, as Guy is frequently saying these days, we're living in the Wild West. They've set up a whole system of administration which basically flaunts the primary legislation, that which has been debated in Parliament, presumably to protect us and to make sure that demands aren't made on us that aren't proper. And it's become so degraded that the Citizens Advice Bureau itself can actually print this stuff to kid us into thinking that the council or the bailiffs or I don't know, a bank or whoever it is can actually print a warrant themselves. Now, most of us in this room know that they do this all the time, but here it is in actual public print that this is what they're doing. Very, very interesting. So I'm at the moment trying to figure out how to bring a claim against the council on the basis that they're not actually following due process. I'm just thinking of ways to do it, and as I say, it's all very new to me, but I'm absolutely blown away by the fact that the legislation actually says in plain words that they have to have proper warrants issued by courts, because warrants and writs cannot be issued by anybody except judges and magistrates. So I think that's pretty much about what I wanted to say.
Debt Free TV, in association with GetOutOfDebtFree.org.